Good afternoon. Attorney Protective would like to welcome you to today's webinar, Social Awareness, Best Practices for Using Social Media in Your Practice. Please reference your materials for information about today's speakers, Kate Gould and John Browning. And with that, I would like to introduce your first speaker, Kate.
Thanks so much, Erin, and welcome everyone. Social media has become a way of life for many of us. Most of you probably use it every day in one form or another, and it seems like new apps are popping up all the time. You may use it for personal communication and entertainment, as well as in your professional life. However, the line between personal and professional can become blurred and becomes a potential ethical minefield for lawyers who can never take off that lawyer hat. "You are what you tweet" is the title of many articles discussing the potential pitfalls of using social media. Once you post that comment or photo, you have very little control about who views it and how it could be interpreted. As a result, we have to take our social media presence as lawyers very seriously. Being new to Attorney Protective, this is my first social media webinar with John Browning. Although I got a head start in everyone by being able to review this material as we were preparing for the webinar, I'm just as excited as you are to hear John, an expert and highly sought after speaker on this topic, present today. As John will tell you, he will never run out of material because courts have to continually address lawyer missteps in their social media usage. Our discussion today will broadly cover this topic, and we will offer general principles for best practices in social media. But as always, be sure to check your jurisdiction for specific guidance in this ever-evolving area. Here's what we'll cover today: a malpractice case review, including what types of issues we are seeing emerge from social media usage, changes to the model rules of professional conduct with implications for social media, using social media for discovery, how the model rules of professional conduct translate to social media, and then we'll offer some tips for steering clear of social media danger zones and for using social media to improve client relations. Hopefully we'll have some time at the end for Q&A as well. I will now turn it over to John to do a review on the social media ethics opinions and cases. John?
Thank you, Kate. It's a pleasure to be here with Kate Gould and for Attorney Protective. Welcome to everyone in the audience. First of all, let's stop and think for a moment just, what kind of environment we're living and practicing in, and what kind of environment our clients are living in. Social media has literally transformed the society in which we live and practice. Inhabitants of this planet spend more than 10 billion hours a day using social media. There are 4.74 billion social media users globally, equivalent to more than 59% of the total population. There are nearly 3 billion people on Facebook, 2.5 billion on YouTube, 2 billion on WhatsApp, 1.4 billion on Instagram, over 1 billion on TikTok. I mean, the list goes on and on and on. And just consider what took place in the span of just the past minute, the past 60 seconds on social media. In that 60-second time period, we saw 293,000 status updates on Facebook alone, over 500 million photos and video shared to Instagram, 360,000 tweets processed by Twitter, and more than 400 hours of footage that was uploaded to YouTube in that minute alone. Over the last year, social media platforms added 110 million new users, and the typical social media user spends close to 2.5 hours a day on social media platforms. Well, I don't have to tell you, that adds up to a very challenging practice environment. And over the past few years, attorneys have seen this, unfortunately, up close and personal. As the slide indicates, we're seeing a variety of whole new issues that have come up from social media usage. We have new causes of action. Yes, you can even defame someone in 140 characters or less. We have new duties that courts have recognized, including a duty to Google. If you have not used the right search engine, if you have not used the right resources in order to locate a particular party to find them, multiple courts have held, well, you have a duty to use technology. We have seen new defenses created by people in this digital age, including the Facebook alibi. People being able to point to their use of technology as an actual defense to a cause of action. We've seen new concerns for employers and for employees, for business owners. Social media's place in the workplace has been hotly debated. Who owns a social media account when a key employee happens to leave and takes his or her Twitter followers with them? Well, we are seeing a huge change, even traditional notions of procedure. Yes, in the past year alone, courts in New York and the highest court in the UK recognized not only service via social media, that's old hat. It's almost as quaint as when we serve people using traditional process servers. For years, we've actually had multiple jurisdictions in 8 different countries, including the United States, recognize service via social media. So this change in our procedural rules has been accomplished via common practice, via legislative action in terms of a statute. It's been accomplished via local rules and standing orders from various courts that service via Facebook or Twitter as an alternative form or a substituted form of service can be committed. But in the past year, we've actually taken that a step further, and we've permitted, as I mentioned, federal court in New York and the highest court in the UK have permitted service of process via NFT, non-fungible token. Essentially, someone getting served via code on the blockchain. We've seen social media change traditional notions of jurisdiction. Remember learning about Pennoyer versus Neff in law school during civil procedure? Well, now we have to take into consideration the, in some aspects, global reach of social media platforms in terms of whether or not they are targeting their business towards a particular individual or jurisdiction, such that jurisdiction might be found in a particular forum state. So we are seeing attorneys being held to a new standard thanks to our changes in just what constitutes competent representation of someone in this digital age. There are 3 cases that are listed here in no particular order. Griffin versus State of Maryland was a 2011 Maryland appellate case that said, yes, attorneys do have a duty to use social media in investigating their cases. In Kennedy versus Adams, a Ninth Circuit case, that upheld a defense and overturned conviction for an individual, a criminal defendant, because his attorney rendered ineffective assistance of counsel. He failed to look up alibi evidence that the client had addressed his attention to that was sitting there on social media. The excuse by the attorney? Well, I just don't understand technology, Judge. That excuse is not going to cut it anymore in the digital age. And in Allied Concrete versus Lester, a Virginia Supreme Court case, that had to do with an attorney's duty to preserve evidence. In this case, digital evidence, specifically Facebook postings that were critical to the case. The lawyer in this wrongful death plaintiff's case said, this content on Facebook is going to kill us. It makes my client, a supposedly grieving widower, look anything but. And so he directed him to, quote unquote, get rid of that stuff. He also had him sign sworn answers to interrogatories saying he didn't even have a Facebook account. Well, you can guess the end of this story. The defense attorneys were one step ahead of them. They realized that he had made various postings. They confronted him with it at trial. The end result was a motion for a rebuttable presumption, a jury instruction, an adverse inference on the spoliation of evidence. Afterwards, the attorney was referred on disciplinary charges to the State Bar of Virginia, and he wound up agreeing to a 5-year suspension, which at his age was equivalent to a disbarment. And that happened to a person who was former president of the Trial Lawyers Association of the state of Virginia and a partner in one of the largest plaintiffs' personal injury firms in the state. So definitely not a neophyte. So we're certainly seeing these sort of changes and our duties, probably beginning first with our duty of competent representation. Rule 1.1, the most fundamental rule of model rule of professional conduct of all, now states that in order to be considered competent in rendering our representation, Comment 8, which has been adopted by 40 states, says we have to be familiar, be conversant with the benefits and risks associated with technology and technology that's relevant to your practice. So this may sound intimidating. Lawyers have come up to me and said, oh, do I need to go back to school? Do I need to learn how to code? Well, it's not quite as extreme as that. However, you do have to be aware that there are both benefits and risks associated with technology that'll be relevant to your practice. This could be something as simple as the fact that you're going to use word processing software in your practice. We're not a bunch of scriveners anymore. It can be that you're going to use technology-assisted legal research and make use of sites like Lexis and Westlaw, or even artificial intelligence tools where it's applicable to the case. We're actually starting to see in Canada, it hasn't happened in the U.S. yet, we're actually starting to see courts that have asked questions of lawyers as to why didn't they make use of artificial intelligence, AI, in doing their work as lawyers in order to keep the fees down. So there are a number of model rules that are implicated. This first one, competent representation, is one. Now, what does tech competence mean in today's digital age? Well, that is a moving target. So, for example, there are only 3 states around the country that have added some form of technology CLE requirement. Florida was the first state in 2016, followed by North Carolina, and just last year, New York added a cybersecurity and data privacy requirement to their CLE obligations. But there are many changes, many model rules of professional conduct that we have seen implicated by social media and technology generally. For example, the duty of confidentiality. Lawyers, of course, have to make a reasonable effort to prevent the unauthorized disclosure or inadvertent disclosure of confidential information. The ABA has issued an ethics opinion on this subject and has discussed the fact that when lawyers communicate with their clients, as we customarily do via email or other electronic means, we need to take reasonable care to protect the confidentiality of these communications. That may mean, depending on the circumstances, using encryption software in order to protect the communications. It is going to depend, according to the ABA's opinion, on the nature of the engagement, the nature of the attorney-client relationship, the expectations of the parties. So, for example, there are many banking and financial technology clients that will actually require of their outside counsel that they have certain technology and certain cybersecurity features as a prerequisite to doing their work. We've seen other model rules of professional conduct that have been implicated as well, including our duty to communicate only with someone who is represented by counsel, and our duties to go through their counsel pursuant to Model Rule 4.2. That has been implicated when we're investigating a case on social media and we see some good information that we want to use, but some of it may be privacy protected. And we know from the publicly viewable information that, gosh, if only we could get permission through a friendship or LinkedIn connection or some other communication with that represented party on social media, then we could get access to all kinds of information. Well, unfortunately, that's the sort of thing that can get lawyers in trouble. And in a case that went up to the New Jersey Supreme Court, that's exactly what was considered when two defense lawyers defending a personal injury case were trying to explain away the fact that their paralegal, at their direction, had sent a friend request to the plaintiff whom they knew was represented by counsel. And when they used some of this information that was discovered, this private information, the plaintiff's attorney got suspicious. And when he tracked down the source of that information, that suspicious friendship connection, he filed a disciplinary action, which, as I mentioned, went all the way to the New Jersey Supreme Court. So lawyers have to be very careful nowadays. We also have to be careful in how we handle digital evidence. Under Model Rule 3.4, we have duties to opposing party and to counsel. And so we have to take care with respect to preservation of digital evidence. And of course, one of my favorite examples has to do with our duty of candor to the tribunal. As a former judge myself, I can tell you, and in conversation with other judges, we have heard of multiple instances where the lawyer has given one representation to the court only to be revealed to be lying by their social media profile. So, for example, in a case in New York, an employment case, the plaintiff's lawyer had missed a deadline to file, filed a motion for leave to extend the time period with the court, said the reason, the good cause for extending the deadline, was the fact that she had been out of the country attending to her sick mother. Unfortunately, that turned out to be not quite true, as the defense attorneys were only too quick to point out. They found evidence from her own Instagram account that, in fact, she had been on vacation in Miami, Florida. She had been partying at clubs. She had been enjoying drinks out on a patio, all while she was supposedly out of the country attending to her sick mother. Well, you can imagine the reaction by the judge. Not only was her relief turned down by the judge, but the judge entered sanctions against her of $10,000. And actually, that was considerably less than what the defense attorneys were doing. Now, this is not the only example of social media misuse getting an attorney into trouble. As you see from your slide, and using social media for discovery, the practice of pretexting, or what I call false friending, can get lawyers into trouble. Now, we've seen where lawyers have misrepresented who they are or what their connection to the case is on social media, lead not only to sanctions from a court, but actually an entire separate legal action, as in the Cope case described on the screen. We've also seen disciplinary action taken in at least two cases involving prosecutors, one in Ohio, one in Pennsylvania, both of whom had actually created false social media profiles in order to communicate with witnesses and unrepresented parties. Now, in that case, in the case in Ohio, the prosecutor or assistant DA had actually been engaged in prosecuting a murder case, and he had two female alibi witnesses, former girlfriends of the defendant. In order to try to shake their alibi, he created a Facebook persona of an entirely fictional person, a so-called another so-called girlfriend, in this case a baby mama of the criminal defendant, and he used this persona to communicate with the other two real-life ex-girlfriends, encouraging them not to lie for the defendant. Well, you can probably guess how this turns out. The lawyer had to be out of the office for a short period of time due to a medical procedure. Someone else took over the file, saw that they had apparently a witness he wasn't aware of, and when the other lawyer returned to the office, asked him for information on who this so-called baby mama was. Well, the lawyer had to admit she was fictional. He had created her. That led the more scrupulous attorney to notify opposing counsel, to notify their boss, the actual DA. A mistrial was declared by the judge, and in fact, that DA's office was removed, and a special prosecutor was appointed for continued prosecution of the case. Now, in the case in Pennsylvania, that was similarly a fictitious persona created by the DA, and she directed the prosecutors in her office to use that persona for communicating with unrepresented parties and with witnesses. Now, when that was discovered, she was subjected to disciplinary proceedings and, in fact, ultimately received more than a year suspension of her license. And probably goes without saying, she is no longer the district attorney in that jurisdiction. Now, a lot of attorneys have asked me the question, John, I started representing this client, and I've just seen this, what's material, some content on their social media page that is really going to hurt our case. Can I just tell them to clean that up, take that down? Well, that is a subject that I can give you a very lawyerly answer of maybe. The answers we'll see from the next slide is actually a more complex one. Now, every ethics opinion that has confronted this has said, yes, you can certainly advise your client to clean up their Facebook page. Multiple ethics opinions from around the country have stated this. However, it comes with an important caveat, and that is because of our duty under Model Rule 3.4 of fairness to an opposing party and opposing counsel to preserve evidence, we have to take care that we actually digitally preserve that evidence. We can tell them to implement greater privacy settings. You don't have to have your Facebook page or other social media profile set so that everything is publicly viewable. You can certainly give advice on what kind of content they post, what the potential ramifications of posting something or not posting something might be. And you have to give that advice to clients, but taking care that even though they may remove or take down social media content, you have to make sure to preserve that content, or at least what may be relevant to an actual or threatened claim or lawsuit, to make sure that no spoliation of evidence occurs, and to make sure that your obligations to preserve evidence are strictly adhered to. So that is my answer to that question as to advising a client to clean up their Facebook page. Let's go ahead and advance the slide, and we'll take a look at the next issue. After advising a client to clean up their social media presence, we also have to abide by obligations on when and where we might tweet or post. Obviously, different courts, different jurisdictions have different rules on what exactly is prohibited. And in most federal courts, for example, there is under FRCP 53 the statement that you're not allowed to engage in photography, recording, or broadcasting from the courtroom. Now, from time to time, lawyers have conveniently forgotten that, and that is a problem. As I mentioned in the slide there, Chicago attorney Vincent Schmelz, he wasn't even trying a case. He was observing a trial in a so-called spoofing case in federal court. Happened to be an area he had some interest in with regard to other cases, and he tweeted from the courtroom. Unfortunately, he tweeted with some pictures of evidence. What he didn't tweet was the prominent courtroom sign saying photography was not allowed. The judge was not amused and ordered Mr. Schmelz to show cause. He was sanctioned, receiving a $5,000 fine, was ordered to do 50 hours of pro bono work, and also to attend a seminar on social media and legal ethics. Now, this use of social media in the course of a case is hardly unknown. Lawyers have gotten into ethical hot water for posting a victory selfie from the courtroom in the immediate aftermath of a trial. That happened in one criminal case in which the lawyer was caught up with the acquittal, which was a great result, but forgot that he was actually in the courtroom. He took the victory selfie with his client, his obviously jubilant client, and then posted it on Facebook. The judge did not click like. Now, other cases have happened involving lawyers' misuse of social media in their cases themselves. A couple of years ago, in a large pharmaceutical tort trial in Philadelphia involving the drug Xarelto, two attorneys who had been admitted pro hac vice in the case in Philadelphia had been posting throughout the trial photos from the courtroom to their law firm Instagram account, along with the hashtag Killin' Nazis, a reference both to the Quentin Tarantino movie Inglourious Basterds, but also a reference to the German-based client that was, or German-based defendant that they were opposed to, Bayer. And the judge was not amused. He found their xenophobic strategy, as he called it, something that was beneath the dignity of the legal profession. He took action against the lawyers, including removing them from being admitted pro hac vice. He also ordered certain sanctions against the lawyers. So you have to be careful not only about what you post, but when and where you might post that. Most recently, a solo practitioner doing a medical malpractice case in Pennsylvania was making TikTok videos that incorporated content from depositions that he'd taken of the defendant, Penn Health. And obviously they were not amused by this use of actual official proceedings, and they initiated a disciplinary action that is still going on. Now, these sort of actions can be very serious. In fact, one Louisiana attorney was disbarred after what the Louisiana Supreme Court described as a social media blitz, in which he made numerous postings of various judges, had orchestrated online petitions calling for their removal from office. According to the Louisiana Supreme Court, it was littered with misrepresentations and outright false statements, and she wound up being disbarred. Similarly, in Florida, more recently, another attorney who went on social media and unleashed a barrage of comments about the judge who had presided in the case was made the subject of disciplinary action. So that is one of those issues, and I mentioned the Iowa lawyer, Roxanne Conlon. Timing can be everything, particularly when one is concerned about potential tainting of a jury. Be careful about what you post on Facebook, and be careful about when you might post it. In fact, it's probably not a bad idea not to post anything at all. Ms. Conlon had posted on Facebook questioning whether or not she could her client could receive a fair trial immediately before it started. Now, the judge granted in that case an emergency motion to postpone the trial due to concerns that the jury pool might be tainted. And this has happened in other cases. A lawyer in Texas, a criminal defense lawyer, had a habit of posting on Facebook what he called prayers, more spiritual-minded things on Facebook that he coincidentally happened to post just before trial. Well, that resulted in a DA's motion to restrict him from doing that. That was granted. But we've seen lawyers do some very curious things and very questionable things on social media. For example, the Nebraska attorney who decided to go on Facebook in the midst of defending his criminal defendant client and call his client a stupid person. Actually, I think he used the phrase an idiot and a very poor criminal. That is not a good thing to say, and that can certainly wreak havoc with our system's presumption of innocence. But it's nothing compared to what a Nashville, Tennessee attorney did that resulted in disciplinary action by the Tennessee Supreme Court. He went on Facebook and essentially gave instructions to a supposed victim of domestic violence, domestic abuse, who had asked for input, for comments from people on Facebook about how to deal with her abusive ex. The attorney, and by the way, he identified himself as an attorney, proceeded to describe how she could essentially get away with murder by inviting the ex in, killing him, and claiming that it was self-defense, when in fact it was anything but. The ex got wind of that advice, notified local DAs, and they in turn issued or initiated a disciplinary complaint that was heard and granted by the Tennessee Supreme Court. We've seen lawyers engage in all kinds of things and crossing that line from zealous advocacy to something far more serious. One attorney in Indiana was representing the wife in another family law case. He decided that he would go on Facebook and directly engage with the soon-to-be ex-husband, only he really took things way too far, way more serious than zealous advocacy, because he threatened that person. He said, "I've got you in my crosshairs now," and he threatened him with anal rape. That resulted not only in a disciplinary complaint that the lawyer had to deal with that resulted in a suspension. It also resulted in criminal charges of posting a legitimate criminal threat. The lawyer was successful in plea bargaining that down to a misdemeanor, but he was initially charged with a felony. So lawyers have to take care about exactly what they say on social media and when they say it, when they post it, and they have to be careful in today's modern digital age about what they post, when they post, and how they post. Let's go to the next slide. And while we're waiting for the next slide to advance, let me go ahead and toss it over to Kate to discuss how other model rules of professional conduct can translate to social media.
Thanks, John. I'm going to do a short highlight of those other model rules and offer some practice tips as well. Please look at the PowerPoint for even more detail than I'll be able to cover today, as we have about 11 rules listed and 15 minutes to cover them. We're first going to address Rule 1.3 on diligence. You may wonder how the duty of diligence can be impacted by a lawyer's use of social media. Rule 1.3 states, a lawyer shall act with reasonable diligence and promptness in representing a client. The commentary to the rule, among other things, makes it clear that a lawyer should take whatever lawful and ethical measures are required to vindicate a client's cause or endeavor. Consider this. If a lawyer can conduct a more thorough investigation or background check twice as well and twice as fast through the use of social media, is our ethical obligation with respect to diligence triggered? Perhaps. In terms of the practical application of this rule, we can't hide our head in the sand when it comes to social media. We have a duty to know what it is and how to use it ethically and effectively, and the court and your client may also have the expectation that you use it with speed and promptness, or in other words, with diligence. On the next slide, we'll look at communication. Rule 1.4 addresses communication and at its core requires that communication be prompt and reasonable, as specifically outlined in the rule. No doubt social media can be a quick, easy way to communicate with the client, but be careful you don't go too far. ABA Formal Opinion 477 cautions us on what technology we use to communicate with clients, especially if the information discussed is very sensitive. From a risk management perspective, best practice would be to keep your communication more formal, whether it be in an email or a letter. If you're looking for more information about what you can put on your website in terms of what is allowed and for disclaimers, see ABA Formal Opinion 10-457 on this topic. We'll next look at conflicts of interest. Identifying conflicts of interest can be challenging for even the most seasoned practitioner. We actually have an entire webinar devoted to conflicts of interest coming up in June. Even if you think you understand the conflicts rules, we suggest reviewing them each time you are faced with a conflict to analyze. Let's look at the rules in the social media context. Rule 1.7 precludes a lawyer from representing a client where such representation is materially limited by a personal interest of the lawyer. Again, because you are what you tweet, your personal interest may be on display for anyone to see, whether on Facebook, Instagram, or LinkedIn. Best practice is to limit what you post or even what you like if you don't want the information to be used against you later to try to establish a conflict, in particular, positional conflict. Rule 1.8 states that even where no attorney-client relationship is created, a lawyer who's had discussions with a prospective client shall not use or reveal information learned in the consultation or represent a client with interests materially adverse to those of a prospective client in the same or substantially related matter, if it could be harmful to that prospective client. Where does this rule come up in social media? Well, unless your online contacts or friends are very small in number, the chances are good that you don't know enough about who is seeing your posts. They can potentially be adverse to your client, or they may know who the people are. We have to be especially careful about social media because of conflicts. Remember that online communications can constitute a conflict of interest depending on who sees them. Here's a practice tip for your professional and personal social media. Avoid providing one-on-one advice, soliciting additional information, or expressing legal opinions online. Each of these may conflict you out of a case. You should also develop strong disclaimers to make it clear that no legal advice is being provided and no attorney-client relationship formed based on your posts, blogs, or other social media activity. Another practice tip: contrary to what your marketing objectives might be, the more you are out there online, the more potential there will be to be conflicted out. So it's a balancing act. Choose carefully what you share online and what you do online. We'll next look at duties to former clients. Rule 1.9 prohibits a lawyer who has formally represented a client in a matter from a certain conduct, including representing another person in a substantially related matter in which that person's interests are materially adverse to the interests of the former client without the former client's written consent. The commentary to this rule explains that after the termination of the attorney-client relationship, the lawyer has continuing duties with regard to confidentiality and conflicts to former clients, and may not reveal or use that client's confidential information. What is the practical application of this for social media? Like conflicts in general, Use care to avoid inadvertent clients. Look for ways to configure your profile settings to the most restrictive privacy and security settings. Now on to duties to prospective clients. Rule 1.18 states that a lawyer who has learned information from a prospective client shall not use or reveal that information, except as Rule 1.9 would permit, with respect to information of a former client. This is important. The commentary to the rule tells us that prospective client status is more likely to be found if the lawyer is advertising in any medium and specifically requests or invites information about a potential representation without clear warnings or cautionary statements that limit the lawyer's obligations. Avoiding an inadvertent attorney-client relationship is even more difficult in social media because lawyers cannot always control the flow of information from prospective clients, but you can control the flow of information to the prospective client and how you interact. Here is a practice tip. All social media should include prominent disclaimers on any content or links. An even safer practice is to require an online acceptance of certain conditions, including that there is no legal advice provided and that no attorney-client relationship is formed. General legal information that is current is usually a safe zone, but use caution going to the next step of tailoring it to any specific person, entity, or situation. On our next slide, we'll look at fairness to opposing party and counsel. This is Rule 3.4, which states, a lawyer shall not unlawfully obstruct another party's access to evidence or unlawfully alter, destroy, or conceal a document or other material having potential evidentiary value. A lawyer should not counsel or assist another person to do any such act. Practically speaking, this may mean you need to update your litigation hold letter because spoliation applies to social media postings too. As John discussed, it's considered a serious offense by courts. Make sure the letter references the litigation hold being extended to social media profiles, blogs, and any other content. The next slide is trial publicity. Rule 3.6 prohibits lawyers participating in matters involving or potentially involving adjudicative proceedings from making public statements that will have a substantial likelihood of materially prejudicing that adjudicative proceeding. In most jurisdictions, social media statements are likely to meet the definition of public statements. Additionally, we sometimes forget that a statement can be truthful and still violate Rule 3.6. Ask, does it have a substantial likelihood of materially prejudicing the adjudicative proceeding? Quite frankly, if you have to ask, it probably does. Here's a practice tip. As tempting as it is and as easy it is in social media to try out theories, do not make inflammatory or prejudicial statements via social media. In general, it's risky to talk about specific cases in social media. Not only do negative comments about specific cases or the people involved have ethical implications, but it also turns people off. We'll next look at dealing with unrepresented persons. Rule 4.3 states that a lawyer shall not state or imply that the lawyer is disinterested when dealing with a person who is not represented by counsel. Further, if the lawyer knows or reasonably should know that the unrepresented person misunderstands the lawyer's role in the matter, the lawyer shall make reasonable efforts to correct the misunderstanding. In the commentary to this rule, it distinguishes between situations involving unrepresented persons whose interests may be adverse to those of the lawyer's client and those in which the person's interests are not in conflict with the client. Because social media is a rich resource for investigating adverse parties and witnesses, as we discussed previously, lawyers need to know how to do it ethically. Here's the practice tip. A lawyer can access only what is available publicly and cannot use subterfuge to gain access, even with unrepresented parties. Of course, be sure to check about any particulars on this topic in your jurisdiction. We'll next look at the responsibilities of partners, managers, and supervisory lawyers. ABA Model Rule 5.1 says that lawyers who have supervisory authority over the work of lawyers and firm staff must take steps to ensure the work conforms to the rules of professional conduct. Please note that you may be responsible for the actions of the people you supervise. Your paralegal or legal assistant must not friend judges or use deception to gain access to private Facebook or other sites. From the firm management perspective, establish internal policies and procedures that clearly state your firm's guidelines and rules on social media use. Have a very specific firm policy about what is allowed and what is not allowed. Be aware that the NLRB may also have a position as to what those guidelines can contain. With respect to communications concerning a lawyer's services, we'll look at the advertising rules in Rules 7.1 through 7.5, which probably have the most jurisprudence around them with regard to social media. A special note is LinkedIn. I'll cover the advertising rules quickly and then highlight some challenges with LinkedIn. Rule 7.1 prohibits false or misleading communications about the lawyer or the lawyer's services. The prohibition in this rule extends to lawyers' websites and other social media. The practice tip here is for you to police what others say about you. You may be required to take action to remove or correct the statements or recommendations made by others. On the next slide, we'll look at advertising. Rule 7.2 states that subject to the requirements of Rules 7.1 and 7.3, a lawyer may advertise services through written, recorded, or electronic communication, including public media. However, the lawyer may not give anything of value to someone for recommending the lawyer, with certain exceptions provided in the rule. Advertising rules differ by jurisdiction, and the rules involving social media are still evolving. So again, be sure to check your jurisdiction. The next slide addresses direct contact with prospective clients. This is the solicitation rule. Rule 7.3 requires that communication soliciting employment from people known to be in need of legal services in a particular matter must be explicitly labeled as advertising material. The comments to this rule offer further guidance on what is and is not a solicitation. Specifically, your website or social media posts must comply with the advertising rules of your jurisdiction, as well as other different jurisdictions. It's really a global approach because what you post may reach further than your home state. Before sending public or private social media communication to another user, think about whom the intended recipient is and why you're communicating with that particular person. For example, a Facebook friend request offers to provide legal services to a non-lawyer with whom you do not have an existing relationship may very well rise to the level of a prohibited solicitation. The next slide addresses communications of fields of practice and specialization. Rule 7.4 provides an attorney cannot claim a specialty unless it is in admiralty or patent law, or unless the lawyer has obtained the requisite certification. As with any communication, a lawyer's communication via social media must comply with these restrictions, and some social media platforms make it easy to violate this rule, including LinkedIn. Lawyers and clients' recommendations of each other, even the vague ones like the best lawyer I ever used, can potentially violate this rule. Now let's look at some of the pitfalls of using LinkedIn. There are a lot of ethical opinions, including those from New York, Philadelphia, and Florida, that have dealt with the ethical concerns about LinkedIn listings with regard to the sections entitled Skills and Expertise and Specialties. This culminated in changes being made at LinkedIn that gives lawyers the ability to alter the heading under which they list their practice areas. This new feature allows the users to remove the heading Specialties. For more guidance, I recommend the New York City Formal Bar Opinion 2015-7, which discusses the various aspects of LinkedIn in depth. Finally, I'll take a look at firm names and letterhead. Rule 7.5 regulates law firms' use of trade names and two of its provisions, prohibiting use of false or misleading names and requiring identification of jurisdictions where lawyers are admitted, relate to social media. Because the domain name of a law firm's website is uniquely associated with the firm, it can be considered a trade name. Therefore, Rule 7.5 requires that it comply with Rule 7.1, meaning it cannot be false or misleading. I'll now turn it back over to John to talk about the social media danger zones.
Thank you, Kate. So, how do we steer clear of social media danger zones? Well, the first rule is treat social media as simply another form of communication that's subject to the same ethical limitations as more traditional forms of communication. And adopt a consistent firm-wide social media policy. Some firms call it digital usage policy or electronic communications policy that considers the particular rules of professional conduct for your jurisdiction, as well as formal ethics opinions and, of course, the developing case law that we've discussed nationwide. Consider everything that you do digitally as being something that is going to be forever available. I mean, there is, as the line from the movie The Social Network goes, the internet is not written in pencil, it's written in ink. So consider everything as being permanent and forever available. And with respect to your obligations as attorneys to be tech competent, a lot of attorneys come up to me after presentations like this and say, I'm just going to, close my social media account. Well, I don't think that's a wise move because you are going to be charged with the duty of being aware of what's out there, of being conversant in the benefits and risks associated with technology. So don't just stick your head in the sand. You have to consider social media's implications for your practice of law, and you have to adjust how you do things to account for these additional responsibilities. Now, I have had lawyers in just about every specialty area tell me, well, John, I'm just a humble X, estate planning attorney, tax attorney, transactional lawyer, judge, appellate lawyer. Social media really doesn't impact what I do. Well, you're fooling yourself if you believe that, because I can point you to examples from literally every practice area of how social media has impacted the practice of law. So be aware that it does have implications for your practice, and take steps accordingly. Finally, steer the content on your social media pages to something that is educational and informative or editorial in nature, something general. Don't mention specific cases that you're involved in, even when you're, using names have been changed to protect the innocent, so to speak. Try to have something that's a little bit more generic in terms of your online presence. Think of being something that shows you to be the thought leader, the professional that you are, and not someone who's spilling the tea about their respective clients. So, with that, Kate, how about some tips for using social media to improve your client relations?
Yes, thanks, John. As lawyers, we're in the customer service industry in a sense. For that reason, we want to utilize all the tools at our disposal to improve client relations. To end our presentation on a positive note, let's discuss how social media can be a good tool for that. Social media can be a great way to stay top of mind for existing clients and to impress potential clients. Using social media does provide a means of showcasing your knowledge about a particular practice area that may impact their business or industry. Some ways you can do this are first by setting up alerts to gather information and news on your client, their competitors, and their industry. You can share it with them or reach out to them to show you are paying attention when the opportunity presents itself. You might consider writing blogs. Statistics show many clients view blogs as proof you know your stuff. You can share information about legal developments that could affect their industry for free. It helps to solidify relationships with existing clients and draws in new ones. And if done right, blogs are not advertising, so it's easier to navigate the ethical rules. Twitter can be a great collaboration tool with other professionals and experts. You can follow experts in your field, gather information, and spot trends. Again, be sure to stay clear of the hot button issues and issues that might conflict you out of potential cases. Just remember on all platforms to focus on delivering information and not on advertising or soliciting. As we're getting to the 2 o'clock hour or 1 o'clock hour if you're on Central Time, I'll now turn it over to Erin for the Q&A.
Great. Thanks so much, Kate. And just to say, we had over 2,000 attorneys join us for today's webinar. So I think this really goes to show what an important topic this is, and certainly one that attorneys across the nation are interested in learning more about. So Kate and John, fantastic job today. Thank you so much for sharing your expertise with us. So with that, we have a lot of great questions coming in and also a lot of complimentary comments as well about the presentation. So again, John and Kate, thanks so much for sharing your expertise. Are lawyers responsible for communications between their paralegals and clients on their personal social media accounts?
So let me jump in and take this, and certainly I encourage Kate to chime in wherever she deems appropriate. Of course, under Rule 5.1 of the Model Rules of Professional Conduct, we do have supervisory responsibilities over lawyers who are more junior to us or over non-lawyer assistants, and that would certainly include paralegals. So attorneys can definitely be responsible under this duty to supervise for communications that might take place on social media between paralegals and clients. So you should encourage your paralegals and indeed anyone under your supervision either not to communicate via social media with clients or to do so only via approved channels rather than on social media, and obviously to do so in a manner that's consistent with your ethical obligations.
Thanks, John. I think this question also highlights the importance of having a solid social media policy in your office and following those protocols, and perhaps in training your staff and subordinate attorneys that you give them just examples so they have a better understanding of what is approved and what they shouldn't be doing.
Okay, moving on to our next question. Isn't it the case that a lawyer could only check social media posts that are public? If so, is our duty of due diligence on social media limited only to public posts?
So I'll jump in first with this one too, if Kate doesn't mind. First of all, some of this hinges on what exactly is the lawyer's purpose on reviewing social media posts. So, for example, if I'm researching prospective jurors online, there's an ABA formal ethics opinion, 466. There's also a number of state ethics opinions on the subject that state that we are allowed to review the posts, the online presence, so to speak, of prospective jurors, but we are not allowed to, of course, to communicate with prospective jurors. So if I were just driving down a prospective juror street, this is the equivalent of me noticing, oh, well, the landscaping of their house is neat and tidy, and, they live in this kind of house. Whereas to see the privately available content would be the equivalent of me stopping my car, going up to the front door, knocking on the door, and basically letting myself in. And that, of course, is not permitted. So passive review of what is publicly accessible is fine. Of course, if someone is a party or witness and is represented by counsel, we have to go through their attorney as far as any kind of communication. But if they're not represented by counsel, we, as long as we're not misrepresenting who we are or our connection to the case, may engage with them on social media, and we may, in the course of that, request communication or access via friend request or a LinkedIn connection request, for those non-jurors with whom we're allowed to communicate. But we definitely have to keep in mind that, primarily speaking, our duty, our diligent duty of competent representation, is primarily limited to what is publicly viewable. And if we become aware that they may have some private comments that could be germane, to the matter that you're engaged in, well, you might consider requesting access, but you can't misrepresent who you are, your connection to the case.
Great. Thanks, John. And I want to remind everyone that we are past the 60-minute mark, so it's not necessary to remain on the line for the full Q&A to receive credit. We, of course, hope you stay with us. But with that, I'll just ask maybe one or two more questions. So the next question is, why do I have to preserve my client's Facebook post? Doesn't Facebook keep everything?
Well, I wish that were true. Unfortunately, different social media platforms have different policies with regard to the time frames within which they maintain or preserve content, and they're free to change those time frames as they do change their policy in terms of use. So don't depend on Facebook or some other platform to quote-unquote preserve your client's deleted content. The fact of the matter is, if you are aware via something like, obviously a lawsuit being filed or a claim being filed or even a demand letter, if you have reason to anticipate litigation, then you are under a duty of preservation. And so you do have to preserve those that you are aware of. And in fact, many attorneys are now incorporating so-called social media clauses into their client engagement agreements, into their contracts with clients that will, address this issue, such as the client agrees not to be active on social media during the engagement because the attorney is going to have to keep up with that. The attorney is going to have to, address this in the initial meeting or consultation at the very formation of the attorney-client relationship. Unfortunately, bad things can happen to lawyers who are unaware of what their client is doing on social media. I'll give one high-profile example, and that was in the bankruptcy filing of the entertainer and rapper 50 Cent. Of course, he filed for bankruptcy after having a multi-million-dollar judgment entered against him. And in bankruptcy, of course, you're telling your creditors that you have insufficient funds with which to pay them. Well, while his lawyers were taking that stance, 50 Cent was posting widely on Instagram, and he had a fairly robust Instagram following, of pictures of himself with stacks of cash. Well, this was certainly contrary. The image that he was trying to convey was certainly contrary to the image his lawyers were trying to convey in federal court, and it prompted the opposing lawyers for the creditors to ask certain questions and for the federal judge to issue a show cause order. Now, everything was resolved, but you definitely want to know what your client is up to on social media. There have been instances of clients violating confidentiality and non-disclosure clauses, and voiding settlements because of their postings on social media. There have been, clients who really have complicated or damaged and undermined their case because of what they've posted. So you do want to know what your client is up to.
I don't have anything to add to that, Erin. Yeah, great response, John.
I was going to say great response, John. Thank you. Well, at this point, we are out of time for further questions, so that concludes today's event. And on behalf of Attorney Protective, I would like to thank all of you for joining us for today's webinar. And I would also like to thank our speakers, Kate and John. So thank you, everyone, and have a great day.